Ready, start. We have to now consider the question of assessing the alimony for the respondent upon the dissolution of marriage between the parties. Full stop. Learned Senior Counsel for the appellant has fairly submitted that the appellant is willing to pay a reasonable lump sum of money as permanent alimony to the respondent in order to assist her in starting her life afresh and to put an end to multiple protracted litigations. Full stop. The respondent blatantly declined the said offer, stating that she was not interested in the money of the appellant as her sole intent was to have an opportunity to resume her marital life. Full stop. Before going into the details of the financial position of the parties, it is imperative that we highlight the position of law with regard to the determination of permanent alimony. Full stop. This court, in the cases of Rajneesh versus Neha, Kiran Jyot Mani, within bracket Supra bracket close, and Praveen Kumar Jain versus Anju Jain, provided a comprehensive criterion and a list of factors to be looked into while deciding the question of permanent alimony. Full stop. It is a matter of record and an admitted fact that the respondent is currently employed as a research specialist at PwC in Kolkata, earning a salary of rupees 50,000 per month. Full stop. In her reply affidavit, the respondent averred that the appellant earned rupees 8 lakh per month in 2018 and claimed that he would now be earning more than rupees 10 lakh per month. Full stop. The appellant, in his rejoinder affidavit, admitted that while he was earning rupees 8 lakh per month in 2018, however, at present, he is unemployed and is facing challenges in securing employment in India due to multiple cases filed by the respondent. Full stop. Considering the peculiar facts of this case, a one-time settlement as alimony for the respondent would be a fair arrangement. Full stop. Taking into account the standard of living enjoyed by the respondent during the subsistence of the marriage, the prolonged period of separation, and the financial status of both the parties, an amount of rupees 25 lakhs appears to be just, fair and reasonable to be paid by the appellant to the respondent towards settlement of all pending claims and to cover the permanent alimony. Full stop. The appellant shall pay the amount provided above towards permanent alimony to the respondent within a period of 2 months from today. Full stop. Before we conclude our discussion, we must note that the act of impounding the passport of the appellant by the concerned authorities of the Government of India was ex specie illegal in the eyes of the law. Full stop. In the present case, the appellant's passport was impounded on the mere premise that the respondent has filed numerous cases before the various courts in India. Full stop. The law regarding the impounding of a passport of an individual has been settled by this court in the case of Menka Gandhi versus Union of India and another, wherein it was held that the rules of natural justice must be followed before impounding a passport under section 10 within bracket 3 of the Passports Act, 1967. Full stop. Now it is obvious that on a plain natural construction of section 10 within bracket 3 within bracket C, it is left to the passport authority to determine whether it is necessary to impound a passport in the interests of the general public. Full stop. But an order made by the passport authority impounding a passport is subject to judicial review on the ground that the order is malified, or that the reasons for making the order are extraneous, or they have no relevance to the interests of the general public, or they cannot possibly support the making of the order in the interests of the general public. Full stop. It was not disputed on behalf of the union, and indeed, it could not be in view of section 10 subsection within bracket 5 that, save in certain exceptional cases, of which this was admittedly not one, the passport authority is bound to give reasons for making an order impounding a passport, full stop. We, comma, however, comma, wish to utter a word of caution to the passport authority while exercising the power of refusing or impounding, comma, or cancelling a passport, full stop. The passport authority would do well to remember that it is a basic human right recognized in Article 13 of the Universal Declaration of Human Rights, with which the passport authority is interfering when it refuses or impounds, comma, or cancels a passport, full stop. It is a highly valuable right which is a part of personal liberty, comma, an aspect of the spiritual dimension of man, comma, and it should not be lightly interfered with, full stop. Cases are not unknown where people have not been allowed to go abroad because of the views held, comma, opinions expressed, comma, or political beliefs, comma, or the economic ideologies entertained by them, full stop. It is hoped that such cases will not recur under a government constitutionally committed to uphold freedom and liberty, but it is well to remember, comma, at all times, comma, that eternal vigilance is the price of liberty, comma, for history shows that it is always subtle and insidious encroachments made ostensibly for a good cause that imperceptibly but surely corrode the foundations of liberty, full stop.